And we're going to count one only,
Yes, ma'am.
correct?
Yes.
Mr. Valentino, in cause number 25, BCCR 0120, the state's elected to proceed on count one only. Just went away. Hold on. It alleges you committed the state jail felony offense of theft of material, aluminum, bronze, copper, or brass from April 7th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
It's not.
And are you pleading guilty because you actually did what they charged you with?
It's
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you reached with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for an 18-month term. Oh, y'all put county jail. That's state jail, right?
It's state jail. Yes,
That's
ma'am.
right. In the state jail prison. And you would receive credit from the date of that arrest. We've talked already on the record that you were in custody in TDC from the time of this arrest. You were immediately transferred to TDC on another case, correct?
Yes, ma'am.
And the clerk has done the calculation, and it looks like that would be 600. Is that a
55, yes, ma'am.
655 days that you would receive on your sentence. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Valentino is not competent?
No, Your Honor.
And so, Mr. Valentino, it's my understanding that we're talking with your attorney, that you need just a short amount of time so that you can go into custody. You weren't prepared for that today. What I'm willing to do is reset your case for sentencing till next week on Monday, and then you can come back and we'll sentence you on that day. Yes, sir.
Judge, and speaking with Mr. Valentino, as you know, he was recently released from prison. He was able to find a job. He is working now, taking care of a sick mother. He was asking if we can get 30 days just to make sure that stuff he doesn't lose all that stuff when he, because he's going to have to go into custody. He'll be away for some amount of time after he does come back and get sentenced.
I'm not going to do 30 days. I think I understand that you've been in custody, but you also have some criminal history that gives me some concern. The most I'm willing to do is 2 weeks. Ms. Malfino, any issue with that? All right. So I'm going to reset your case for 2 weeks. Now, there's some very important things about that, which a couple of things. Number 1, obviously, if you're arrested for anything between now and when you come back, I'm not going to accept this plea agreement. Things could be much worse. With your criminal history, this could be a TDC case. You could end up with more than 2, obviously more than 18 months in the state jail. Also, if you don't show up on that date, then the deal's off and there'll be a warrant for your arrest and you're looking at a lot more time. Do you understand that as well?
Yes.
Right. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Valentino is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. Did I already say all this? It's been a long day.
Thank you.
I did, didn't I? I thought so. Started sounding familiar. All right, so what I'm going to do then is reset your case again. We don't need a pre-sentence report, and we'll just come back for sentencing in 2 weeks. All right? Okay, see you back then.
Thank you, Judge.
I started saying that. I was like, wait a minute, because I get sidetracked saying any though. No paperwork on that. Good morning, sir. Are you Joshua Barlow? And this is a motion to revoke probation. It looks like Mr. Barlow is on probation for possession of a controlled substance, penalty group 1. What is the announcement?
Judge, Mr. Barlow did retain me to represent him over in Harris County in regards to the new law violation, and actually also partially the technicals. As part of that was about living or being in Harris County during that time of the offense. We were in court Thursday. There is a 911 recording that we will have probably either today or tomorrow. That is going to say a lot before it's about whether they're going to proceed with the case over there. And also, honestly, if they're going to file new charges against the complainant. As well as I think that will also give us a lot of insight into the technical violation of his residence at the time because of the information that would have been given over that video. So I'm just asking for a short time so we can listen to that. Listen to
Okay.
that.
And as far as everything going okay right now on
Yeah,
probation?
sure.
Okay, all right, so we'll just do a normal reset so you can get all that information, get it to Ms. Malfino, and then we'll see where we are on that next court date.
Judge, in light of the violation alleged in count 6, which is the positive UA on March 4th of 25 and April 8th of 25 for marijuana, he does not currently have a drug patch. I'm assuming from Officer Kitchens that he has no UA violations during the pendency.
I gave him a drug test, 310 this month, anticipating this court appearance, and he tested negative.
Okay. Obviously, if there's any issues, just let me know, or we can get that drug patch ordered real quickly if we need to. All right.
And Judge, also, Mr. Barlow did let me know that he does have he sent me over confirmation. He has a job interview tomorrow at 10:30.
Okay.
So we just wanted to make sure you all have that because he is, of course, on restrictions with the GPS monitoring.
Okay, just send that over in a memo if you would, so that I know, make sure you talk to probation so they know where you're going as well. Okay? All right, thank you. Corey Richardson, Mr. Crenshaw. Right, sir, you're Corey Richardson. And will your client waive the formal reading of the indictment?
We do, Your Honor.
Mr. Richardson, and cause number 25 DCCR 0249, the state has elected to proceed on the lesser included offense of a Class A misdemeanor attempted solicitation of prostitution from November 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you've done what they charged you with? Speak up.
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 2-year deferred probation. Is there a fine?
I believe there is a $500 fine on
I
that.
mean, it's up to the court, but I would think there would need to be a fine. If y'all want to agree to something, that's fine. If not, I would impose 500 for sure.
500's fine, Judge.
So there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding of your agreement?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
Yes, Your Honor.
No objection.
It's admitted. Is there any evidence that Mr. Richardson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily to the lesser offense of Class A misdemeanor attempted solicitation of prostitution. Find that you entered that plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings for a period of 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have the conviction on your record. And at the end of the probation, if you're successful, the case would be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sent to the Jefferson County Jail for 1 year. Do you understand?
Listen.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so watch for her to put it in. Okay, good luck to you, sir. Thank you.
Thank you, Judge. Thank you, Miss.
You're welcome. Last one.
I think that's every active case I have on your file.
Well, you need to get some more.
Yeah. To go back to work. Thank y'all. Have a great day. It's stayed forward at 8:15 this morning. She's giving me an announcement. She can't get it, but you'll have it.
Mr. Lewis on Janisha Jackson. Right, ma'am, you're Janisha Jackson.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does.
So did we start something and then not do it? Us on the 2nd? Were we here March 2nd? I show that I have a revised indictment already.
I don't recall that.
Okay. See, I made a note on it. Oh, we must have been, that's when I made the change to the heading.
Yes.
Okay. So, Ms. Jackson, in cause number 25 DCCR 0903, you're charged with the state jail felony offense of abandoning or endangering a child from May 26th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. And also there's part of the agreement is that you would not request early termination from probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, objection.
It's admitted. Is there any evidence that Ms. Jackson is not competent?
No.
Right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea.
Yes.
Find sufficient evidence to find you guilty. However, I'm going to reset your case. I'd like to get a pre-sentence report on it. That'll just give me more information about you and your case, and we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation. She's sitting at that desk right over there.
Yes.
And then we'll see you back at sentencing.
Okay.
All right. Thank you. Thank
Thanks,
you,
Judge.
Lewis. Mr. Let's see. Brittany, do you have something else? No. Okay. Candy, Baraka. Good morning, ma'am. You're Candy Baraka.
Yes, Your Honor.
And Ms. Baraka, you had filed a petition for expunction. Sorry.
Go ahead. It's okay.
You had filed a petition for expunction in 2 cases.
Yes.
One was M241026, which was a failure to identify. And then the other was 23 CCCR 2497, which was a theft of property case. We called your case earlier but
Sorry, Your
we
Honor. I flew in from Los Angeles.
I'm sorry.
I flew in from Los Angeles.
Okay.
I
So
was in the hallway. Sorry.
the state's position, and I already made an order in your case,
Yes.
and also the city of Beaumont was here as well, with the opposition. And the opposition by both of them is to the failure to identify case, which is, hold on, don't
Right.
talk over me, which is M241026. They did not have opposition in the theft of property case. I have agreed and ordered the expunction in the theft case. However, because you pled guilty or no contest, in the failure to identify case and received a probation, you're not eligible for an expunction in that case. If it was a deferred probation, you may have some rights to what's called a non-disclosure. If you finish a deferred probation, as long as there's not conviction, so you'll have to check into that. But and it's not quite as good, I guess, as an expunction, but it is something if it was a deferred probation and if you satisfactorily completed it. So you can look into a non-disclosure for that one.
Okay.
But I did sign it, or I am going to sign the order for the theft, but not the other one.
I'm fine. I just thought that because it was maybe, I think 20 years ago.
Yeah,
It was
unfortunately, the
not-
age doesn't
I'm
matter.
glad you told me how I can go about it.
Yeah, they're required by law to check everyone that comes through, and if you're not eligible, you're not eligible.
Okay.
But you can look at that non-disclosure for the failure to.
And I appreciate you, Raquel.
Yes,
Have a
ma'am.
blessed day.
Ma'am,
Your
did
honor.
you just call me by my first name?
Judge.
We don't know each other, do we?
Fine. No, man. But I
Okay,
do appreciate you. Thank you.
okay, you're free to
Have
go.
a blessed day. Okay.
Yes.
No, if I've had his first name. We go way back, 3 minutes. Oh, that's okay. That's okay. Mr. Rennick, you have John Sharp.
Yes, Your Honor. No, we'll be.
Okay, give me, I'll call it as soon as that's all ready.
You can call me that first thing.
And I wouldn't even, we have known each other a long time and I still wouldn't give it to you in court.
Feel free.
Mr. Rojas, you have Maria Garza.
Yes.
Okay, so we have someone on
We're
the.
going to talk to you about that also.
Okay. Good morning. Are you Maria Garza? And this is 25 DCCR 1008. Ms. Garza is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, we're asking for at least 30-day reset, so Ms. Malpino can send the victim a subpoena, see if he'll show up next time in hearing.
Okay,
That's correct, Judge. I will send a subpoena and a letter, both in English and in Spanish, based on the information received from Mr. Rojas today.
okay.
Ready to endorse.
All right, we'll just do a normal reset to give you time to get that taken care of. And Ms. Garza, stay in touch with Mr. Rojas and your bondsman. They'll let you know when to be back. Okay, you're free to go.
Thank you so much.
And you have Whitley Shepherd.
She may have stepped out for you, but
Whitley Shepherd, if you'll call the name, please.
Really, Shepherd?
Good morning, ma'am. Are you Whitley Shepherd?
Yes, ma'am.
And Ms. Shepherd, in cause number 25 DCCR 1146 is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, Ms. Shepherd and I have previously talked about her case early on. I just got an offer last week and I've talked with her a little bit this morning. I think I need more time to explain to her what it all entails.
Yes, sir. And so, Ms. Shepherd, I'm going to do a normal reset in about 30 days. Make sure you call and make an appointment soon to go visit with Mr. Rojas. So y'all can go over everything, all the discovery, what your options are, and things like that. And then we'll get an announcement at the next court date, okay? Answer out loud, please.
Yes, ma'am.
Thank you. You're free to go.
And now you're talking about.
Good morning, sir. Are you John Sharp?
Yes, ma'am.
Judge, with the court's permission, we're going to proceed on a lesser included Class A terroristic threat public service.
Yes, ma'am. Will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Sharp, in cause number 25 DCCR 1476, the state has elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat. And that's from September 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
It's fine.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them, but the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rennick?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
There is not, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and do your successfully complete your probation, then this is a great opportunity because you don't have the conviction on your record. And at the end of the probation, if you're successful, the case is dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing, number 1, the conviction, and 2, a sentence in our county jail for up to 1 year. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right over there. She's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
All right. Good luck to you, sir.
And Judge, I failed to bring the certificate for discovery up, so I'm gonna bring that right.
Okay, if you'll go ahead and get the one
Yeah,
signed,
right.
please, and then just have email the attachment to Ms. Holmes, please. Yeah, we did.
Cap, regardless of any consent or lack thereof, or the validity of a subsequent K-9 alert or lack thereof. This defendant was going to be arrested, the vehicle was going to be inventoried, and that cash that was inside that vehicle was going to be seized for further investigation as to whether or not it was proceeds of illegal activity.
That's correct.
I have more questions, Judge, but I don't know if that.
Do you have any questions of the witness with regard to the suppression issue? And then you can do that, and then I'll make that determination, and then Mr. Coleman can continue.
I do have a couple questions.
Go ahead.
The vehicle was going to be inventoried, and that cash that was inside that vehicle was going to be seized for further investigation as to whether or not it was proceeds of illegal activity.
That's correct.
I have more questions, Judge, but I don't know if that.
Do you have any questions of the witness with regard to the suppression issue? And then you can do that, and then I'll make that determination, and then Mr. Coleman can continue.
I do have a couple questions.
Go ahead.
Do you know who owned it in 2023 when it?
Real quick, you had stated that the vehicle's inspection sticker, the registration sticker is expired 2023.
Green or not?
As to
Can I look at my notes?
Yes.
It belonged to a Hispanic guy.
Okay. So, and you were able to verify that it
I
belonged to a
have more
Hispanic guy in
questions,
Houston,
Judge,
Texas?
but that's.
We weren't able to
I don't know
verify
if
because he.
Do you have
What was the date you said?
Witness
I'm
with
sorry.
regard-
Will you tell me what was the date that it was last registered, or what date did it become expired?
That expired in March of 2023, and that was through the MDT computer.
Do you know who owned it in 2023 when it became expired?
I didn't document it in my report, but I know it was on the MDT.
Okay, do you know whether it was Ronnie Green or not?
It was not Ronnie Green. As a matter of fact, we had a conversation about that it belonged to a Hispanic guy in Houston, Texas.
Okay. So you were able to verify that it belonged to a Hispanic guy in Houston, Texas?
We weren't able to verify because he no longer had that person's point of contact, cell phone number, and he advised he bought it from Facebook Marketplace, and he was unable to get hold of the owner.
Okay, but you had access to records internally through the police department, right?
Right, but I don't think we keep records of phone numbers for subjects in Houston. I don't think it's gonna document in RMS.
Sure, but I guess my question is, did you verify the name of the owner?
Verify the name of the owner?
I mean, what did your system say who owned it in 2023?
Without that information from me, I would have to go back and run the plate again.
But it wasn't Ronnie Green.
It wasn't running here.
Was it the person's name that he gave you?
Facebook Marketplace. I'm not sure. I would have to watch the video again.
What about in 2025 when this stop was made? Did you look up to see who owned the vehicle at the time that you made the stop?
Yes, the MDT computer. Yes.
Did the computer say that Ronnie Green owned the vehicle?
No.
Okay. Who did it say owned the vehicle?
You're asking a question that I can't remember. I'd have to go back and pull up the MDT computer or the video to watch it.
We may be able to answer that after we watch the video, right?
But possibly.
Okay. But to be clear, in 2025, when you stopped Mr. Green in that vehicle, he was not the registered owner.
That's correct. I would have to watch the video again. I'd have to go back and watch the video.
At any time since then, have you looked up to see at any time has the registration of that vehicle changed?
Yes, so he had the title in the glove box that had 3 owners, but none of them were ever switched over to each owner.
Okay, let me ask you that then. So he had in the vehicle, he had a title,
That's correct.
and it was to that vehicle.
That's correct.
Did you ever look to see if any of the names of owners on that title matched the name that the vehicle was owned by in your system? You don't know how long it's been on the vehicle.
I'd have to go back and watch the video. But none of the names on that title had Green on it.
I understand that. But did any of the names match who you believe to be the true owner according to your internal system that you're allowed to use?
So we'd have to go back and watch the video.
So he had
That's correct.
Do you know what it was to that Reyes for that offense? Did you ever that tag that you believe was fictitious or that was fictitious? You don't know who put that tag on the vehicle, do you?
That's correct.
You don't know how long it's been on the vehicle.
That's correct.
Did you ask Mr. Green if he put that
But
tag on the vehicle?
none of the names on that title.
The reason why you arrested Mr. Green for that violation at some point was because he was the driver of the vehicle. Is that correct? Not because you had knowledge that he had placed the tag on the vehicle.
So we'd have to go back and watch the video. He was operating a vehicle that had a fictitious license plate on it.
Okay. Do you know what the correct mens rea is for that offense? That tag that you believe was fictitious or that was fictitious. You don't know who put that.
Judge, I would object to the legal question outside of the
Assistant.
expertise of this student.
Sorry? Did you ask Mr. Green if he put that tag on the vehicle? So you don't know the reason why you asked Mr. Green if he put the tag on for that?
We were back my notes.
He was the driver of the vehicle. Did Mr. Green ever tell you anything about it? Not because you had knowledge that he had placed the tag on the vehicle.
The only thing that he said had he purchased the vehicle from
Do you know what the
Facebook
correct mens
Marketplace.
rea is for that offense?
He was unable to get a hold of the previous owner to change the
Judge,
title.
I would object to the legal question outside of the.
Assistant.
Yeah, court report, I didn't put it in there. The title showed that.
Sorry?
We'd have to watch the video. I'm not sure. I didn't put that in my report.
So you don't know if you even asked Mr. Green if he put the tag on there?
I'm not even sure. I'd have to go back.
Did Mr. Green ever tell you anything about the tag?
From a Hispanic guy in a different city, but didn't know how. The only thing that he said that he purchased the vehicle from Facebook Marketplace.
Of this case, have you done any investigation?
He was unable to get a hold of the previous owner
Vehicle?
to change the title.
Not at all.
Yeah, court report, I didn't put it in there. And then the title showed that it had 3 different owners from the city of Houston.
Isn't it common? So you don't know if you even asked.
He also advised that he I'm not even sure. I'd have to go
Temporary
back.
tag.
All right, those
Did
changed.
Mr. Green ever tell you? Isn't that basically?
He actually advised he purchased the vehicle from a Hispanic guy in a different city, but didn't know how to get in contact with him. Yeah.
Since the arrest of this case, have you done any investigation as to who owns the vehicle or if the vehicle ownership has changed?
Doesn't.
Not at all.
It was Xerox copy paper plate that was laminated. And the title showed that it had 3 different owners.
It wasn't consistent with a permanent. Isn't it common that when you buy a used vehicle, that it will have a paper plate? Temporary plate that you have received.
I have a temporary tag.
Temporary tag.
All right, those changed.
Isn't that basically what was on the vehicle, some kind of temporary tag?
I mean, there was just, like, it looked like it was photocopied, laminated, and the barcode didn't scan to nothing. They're supposed to be able to come back to,
You've done
what the vehicle is registered to the owner.
But it was a paper plate, right?
It was laminated. It was a Xerox copy paper plate that was laminated.
Was it metal?
No,
It wasn't consistent with a permanent plate.
right, that's correct.
More consistent with like a temporary plate that you would receive when you buy a new or used vehicle.
That's correct.
Isn't that basically what was on the vehicle? And Mr. Green told you he had just bought it used, correct?
About 3 months prior to this stop.
Laminated.
And the barcode didn't scan to nothing. They're supposed to be able to contact us for that office. That matter of fact, he had contacted his mother to the owner. I think he requested the release of his mother said no, because policy. It was laminated with a total Xerox copy paper plate, especially laminated in inventory.
Was it metal?
Vehicle. No.
It wasn't consistent
And the
with
reason
a
why I
permanent
did that,
plate.
right, if you watch video on the scene, I contacted
Consistent
the
with
district
like a
attorney's
temporary
office.
plate that you
Spoke
would
to
receive
two,
when you buy
DA,
a new or used
defense attorney,
vehicle.
or the prosecutors.
Mr. Green told you he had just bought it.
And I was instructed to get about 3 months prior.
Why did you ask for consent to search the vehicle?
On top of whatever. So I knew I was gonna arrest him regardless for that offense. As a matter of fact, he had contacted his mother. I think he requested the release of the vehicle to his mother. I said no, because policy, since we had the total vehicle, especially we're gonna conduct an inventory in the vehicle, suspect vehicle.
So my question is though.
And the reason why I did that, if you watch video on the scene, I contacted the district attorney's office and spoke to two DA, defense attorney or prosecutors to let them know what I have. And I was instructed to get further additional evidence on top of whatever we have in reference to the money, so we can actually investigate money laundering at that point. So regardless, I'm still going to go in that vehicle, still take that money and conduct a further investigation for the money laundering, which I later filed that case.
Okay. So my question was though, is at the time, whenever you saw the money, you got him out of the vehicle, why did you ask for him consent to search his car?
To get additional evidence for the money laundering goods for a future case that I was going to investigate. That's the explanation.
So let me make sure I understand right, okay? So you got him out of the vehicle, you decided you were gonna arrest him right then. But before you acted on that, you called the district attorney's office.
Well, I explained to him, I asked for the search, I explained to him, he asked me why.
Hold on, I wanna make sure we get in the right order of events here.
Yeah, we're gonna go back and laying out to you exactly where I got him out of the vehicle for safety reasons. So I'm not, at this point, don't know if there's any weapons in the vehicle or anything can harm us. If we want to further investigate real life speculations, we got him out of the vehicle. He asked me, I asked for consent, he asked me what for. I say, hey, we have reasonable suspicion that there's possibly narcotics in this vehicle. And I laid out to him, I know you're on felony probation. I know him before. We have a previous encounter with each other. I know you left a no narcotics location, and this is the reason why I'm contacting K9.
Okay, pause that thought. You just gave several reasons why you believed you had reasonable suspicion at that point in time, correct?
That's correct.
Okay, reasonable suspicion gives you the right to detain someone, right?
That's correct.
And you then, because of that reasonable suspicion you had, decided that you wanted to search his car.
For additional evidence towards the money laundering case.
Right. And so you then asked him for that permission.
That's right.
And then that permission would have allowed you then to search the car with his consent, right?
That's correct.
Okay, but he didn't give you that consent.
I didn't give my consent.
And so then you decided to go call the district attorney's office?
I want to figure out how we can further proceed to seize the money that was in the vehicle, because I knew it's from proceeds from illegal activities.
So at that time, you believed you had reasonable suspicion.
That's correct.
Okay. But you wanted additional advice on how to handle that reasonable suspicion or what to do with it?
Additional evidence, or additional evidence to go about the procedure of actually seizing that money.
Okay. So who'd you call?
The district attorney's office.
Okay, well, that's, you called the elected district attorney or you called?
So I talked to Raven Shear, the intake attorney, laid it out to him. He referred me to Kathleen and civil forfeiture, and I spoke to her on the phone. And all that's on video.
Okay, the goal is to get your hands on the money.
For an additional charge of money laundering.
the district attorney's office. And so based on those conversations, was it discussed that you should just go ahead and open a door and just go ahead and get what you want out? Was that the advice you were given?
No, so I already told them that he was gonna go to jail regardless, into inventory. But they suggested or strongly advised that, hey, to get additional evidence, see if the money would alert other the odor of narcotics would, the canine handler would alert on the vehicle for narcotics odor.
Okay, so let me make sure I understand right. You believe you have reasonable suspicion. District attorney's office says, don't just search the car, get a drug dog out. And he has not consented to a search yet.
That's correct.
Okay, so drug dog comes out.
That's correct.
You believe you had reasonable suspicion to call that dog out?
That's correct.
You know you need that, right? You need reasonable suspicion to call it
And
out.
I just explained what all reasonable suspicion I had for narcotics being undue.
Okay. And based on that reasonable suspicion, you decide to employ a drug dog to determine if there's probable cause to search the car.
To alert on the money, to see if it has a narcotics odor.
But you ran the dog on the car, not the money.
Well, if the money's been around narcotics, it's gonna have to do with narcotics.
First of all, you didn't handle the dog, right?
No, I don't have them.
How's that dog been trained?
That officer's here and they can testify to how that dog's trained.
Do you know where that dog got certification?
I don't.
Okay, so you don't really know if it's a drug dog, right? Searching. And based on that.
Well, I do. It's, if they're certified to work for the city of Port Arthur for narcotics odor, I'm sure they are certified.
But you're assuming that based on the fact that a handler shows up with the dog, right?
Right. But you can ask, she's here, you can ask.
Okay, perfect. And we will. So the drug dog comes out, he goes around the vehicle, right?
That's correct.
And then you're waiting on the handler to tell you whether the dog hit or not so that you can then search the car. Isn't that the way it works?
That's correct.
Okay. And so you're standing there and you're not participating in the drug dog searching part, right?
That's correct.
You're waiting on the handler to do their job.
To notify me that they alerted to narcotics odor response in the vehicle.
Okay. And when you receive that, that's when you then search the vehicle.
That's correct.
Okay. Which is basically the way it's always done, right?
That's correct.
Okay. Goes around the vehicle. Right. And then you're waiting on the handler to tell you whether I want to make sure dog hit or not so that you can then search the car. Isn't that way it works? In your statement, in your report on page
That's correct.
right, the vehicle. You're waiting on the handler. 9, can you go to page 9? And when you receive that, that's when you then search the vehicle.
That's correct.
And then, basically the way it's always done, right? On page 9, on the probable cause search, second paragraph, and then once in the vehicle, I'm going to read that sentence to you and I want to make sure that that's accurate. It says, shortly after, K9 Officer Williams arrived on scene and conducted a free air sniff on the suspect's vehicle, right, the vehicle. And then almost immediately, Officer Williams' K9 partner alerted to the driver's side door on the suspect's vehicle, right? So the dog hit on the vehicle, not the money.
That's correct.
Right. And then Officer Williams advised her K9 alerted, which provided us with probable cause search. Okay. And then once in the vehicle, then marijuana was smelled.
Right. That's correct.
That's the proper chain of events, right?
That's correct.
You have reasonable suspicion, so you call the drug dog.
That's correct.
Talk to the DA's office, they say call the drug dog.
That's correct.
Drug dog came out, hit, gave you probable cause.
Correct.
Then you search the vehicle.
It's necessary for me to hear from the witness with regard to.
I'll pass the witness.
Well, I guess let me, maybe I
That's
can
correct.
answer this myself.
Officer Williams advised her K9
My
alerted,
thought is
which
based on.
provided.
So any other questions, Mr. Coleman, with regard to
Dog
the probable cause to search and the suppression issue? Or I think I need to rule on that
Use the word.
before we go any further
He said yes.
into any other testimony.
Probable cause in
Talk
my
to the
opinion.
Not with regard to the
That's
probable cause of the search.
So, Mr.
And I-
Gallimore, do you think it's necessary for me to hear from the witness with regard to, well, I guess let me, maybe I
The
could
arrestable
answer that
officer
myself.
Intended to arrest the defendant.
My thought is based on the evidence, even prior to the dog being called or getting there, that the officer, and I understand, you used the word reasonable suspicion, and he said yes, but it appears as though there was probable cause, in my opinion, earlier than the calling of the drug dog. And I think he testified to numerous reasons that would back that up. Number one, the arrestable offense that he intended to arrest the defendant for, which would obviously lead to the ability to inventory the car. The fact that he saw in plain view the money that was
said yes, that there was also
packaged or separated in a way that through his experience is something that is indicative of drug
numerous reasons that would
dealing and that it was in doper increments in his words. In addition, the knowledge that this officer had of the defendant himself personally from the prior offense that he's on probation for, and in that offense, which is a drug offense, that there was also indications of drug dealing at a house that they were surveilling, as well as a scale in addition to the drugs that would indicate drug dealing and not just personal use. And he also, well, okay, I think that's it with regard to the probable cause for the search. And so at this time, I'm going to.
Judge Mayer,
Yeah, sure.
as it relates to whether there was probable cause at the time, the court stated that that he agreed with the word that I used. Number one, he did point out that in his report, it wasn't until, well, it was at the time that the canine handler alerted to him that the canine hid that he believed he had probable cause. That's what he put in his report. But it was just, it's also his word in his report that he believed the description given as far as the previous offense and the doper money that he saw. Testimony today, the court stated that and that was he agreed. That was the word that I used when we got past this point. But one was that he did point out that in his report, the version is given. Well, was at the time say, "Hey, we were going to find." Oh, it was when Green asked the officer why he was going to search the vehicle. Is the officer, and I don't know if this was actually said specifically, but the officer stated, and it's going to be on the video, that they had reasonable suspicion that narcotics were in the vehicle. So it seems to me that the testimony today has, and that was something else that's going to be developed when we got past this point, but was that the version is being given in a way to say, hey, we were going to find it anyway. But when you look at the officer's perspective at the time, he believed he had reasonable suspicion. Those were his words that he used in his report. He also called the district attorney's office for advice on what to do. And their advice was not to search the vehicle, not that he had already had probable cause, but that he needed to have a drug dog. And then his words that were when the drug dog hit, he then had probable cause to search the vehicle. So the police and the district attorney's office at the time did not believe there was sufficient evidence to determine there was probable cause to search the vehicle at that time. And I tend to agree with them, to be honest with you, and that's the reason why we were having this hearing.
Mr. Coleman.
Judge, I think I agree with the court's line of reasoning and thought process as you laid it out before. I have nothing to add, Judge.
Well, I mean, is there any issue? I guess we can have Officer Lopez step down, get the other officer on. I can hear further evidence with regard to the canine. I don't think in my opinion, I don't believe it's 100% indicative of my, where I'm headed potentially, but it might give me at least more information. So let's do that. If you don't mind, sir, if you'll step down, just stay handy. We'll get you right back in, and then let's get the next witness.
Have a seat, please.
Is there any issue? I guess we can have Officer Lopez step down, get the other officer on. I can hear further evidence with regard to the canine.
Thank you, Your Honor.
I don't think in my opinion, I don't believe it's 100% indicative
State your full name for the
of
court.
my
you know, where I'm
And,
headed
Officer Williams, how are
potentially,
you
but
employed?
it might give me at least more information. So let's do that.
I'm gonna ask you to speak up a
If
little
you don't
louder.
mind.
Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Certified
Have a seat, please.
K-9 handler.
Yes.
Were you certified as a K-9 handler back on March the 3rd of 2025?
Yes.
And were you working that day with your K-9?
You may proceed.
Thank you, Your Honor. Would you please,
Trying to get some of us.
Please state your full name for the court reporter.
Tiffany Williams.
And Officer Williams, how are you employed?
With Arthur PD as a patrol officer.
Okay, and I'm going to ask you to speak up a little louder. The court hears everything you have to say. Are you a certified peace officer?
Yes.
In addition to being a certified peace officer, are you a certified K-9 handler?
Yes.
Were you certified as a K-9 handler back on March the 3rd of 2025?
Yes.
And were you working that day with your K-9 named Athena?
Yes.
Is Athena certified as a K-9? Help me with the terminology. Certified.
She's certified through NNDDA, which is a nationally recognized certification for narcotics.
And was she so certified back on March the 3rd of 2025?
Yes.
And were the two of you called out to the 3600 block of Gulfway in Port Arthur, Texas in Jefferson County that day?
Yes.
And once you arrived, Officer Lopez, the assignment, they were on the scene with a silver Volkswagen that they conducted a traffic stop on, correct?
Yes.
And they had a suspect who was identified as the driver who was standing outside of that vehicle. Did you see him in the courtroom today?
Yes, he's wearing a black hood.
And do you know that his name that he was ultimately identified as?
Ronnie Green. Sorry. Yeah, Ronnie Green.
I asked Your Honor, the record reflect the witnesses identified the defendant.
The record will so reflect.
And
Yes.
the process for running Athena on a vehicle doing a free air sniff, very briefly, could you explain that for the court?
Normally the pattern I use is once I get her out, I let her take a break in a grassy area. If there's one close by, I bring her to the front driver corner of the vehicle. I give her a sit command, and once she sits, I give her a check command. We work normally in a counterclockwise pattern around the vehicle, and we conduct 2 passes if necessary. In this case, she didn't need the 2 passes, but that's typically the pattern that we go with.
Is there any reason you followed that process in this instance, correct?
Yes, we started that process.
You started that process.
Yes.
And at some point, did Athena alert on that silver Volkswagen?
Yes.
In the process, or in the process of alerting on that silver vehicle, well, let's tell the court what you recognize in the way of an alert. How do you determine if Athena alerts on a vehicle?
It's a change of breathing and a change of body posture.
Instances, and you observed that with Athena in this case, right?
Yes.
What kind of substance or substances is or was Athena trained to alert on?
It's marijuana and THC products, methamphetamines, crack, cocaine, heroin, including black tar and powder heroin.
And have you run Athena on a vehicle or vehicles on a few or on many occasions?
Many.
And have you found Athena to be reliable?
Yes.
In fact, have you found contraband in instances where she has alerted on few or on many occasions?
Oh, many.
And in this instance, she alerted on that silver Volkswagen, correct?
Yes.
Now, let's be clear about something for the court. When she alerted, the driver's side window was down, correct?
Correct.
And it would appear that Athena, when she alerted, stuck her nose inside of that driver's side window at some point, correct?
Yes. What she started showing the signs, and then she went up trying to get closer to the source.
And you understand that and you and I have had this conversation, you understand that there is an argument, at least, that by sticking her nose into that vehicle, the argument could be made that that was an improper intrusion into that vehicle and could arguably invalidate the search.
Yes.
But nevertheless, she did alert, correct?
Correct.
Once back at the PD.
Let me make sure, I just want to make sure, did she show signs before she had her nose in the vehicle or after?
Yes, now, so she did both. Whenever you can tell by the way her body is, she'll stiffen her tail and curl it, and she showed the change of breathing, went to the driver's side and then went up after, and then she stiffened her body while she was postured on the car.
that was an improper intrusion. And once back at the PD, what, if anything, was done or conducted?
I followed Officer Lopez and Officer Villasana to the station after the vehicle was picked up, and they set out 5 bags. One contained the money that was inside the vehicle, and the other 4 were blank. I did not know which one the money was in. They just had them out ready for me to go when I got there. And I again ran Athena on those money bags, and she showed a response to one of the bags, which I later learned contained the money.
What is this that I'm marking? What kind of a device is this?
It's a flash drive.
You were equipped with a body-worn camera that day?
Yes.
The body-worn camera was properly operating as far as you know?
Yes.
You as the operator properly, certainly capable of properly operating it?
Yes.
This interaction, the dog alert on that silver Volkswagen was captured on your body-worn camera?
Yes.
May I approach the witness?
You may.
And I am going to show you what I am marking as State's Exhibit number 1. And I'm going to ask you first to identify this device for the record. What is this that I'm marking? What kind of a device is this?
It's a flash drive.
And the flash drive, you recognize it how?
Yes, I reviewed it and it has my initials and today's date on it.
The dog alert on that. Is this the body-worn camera that you just testified about containing the interaction with the vehicle that
Yes.
Athena alerted on?
Yes.
True and fair, accurate copy with no alterations or deletions as far as you know?
Correct.
That was the last time you watched it?
A little while ago.
Just before testifying?
Just before testifying.
State officer states, one, been previously provided to defense counsel in discovery. No, Judge.
States one's admitted.
Commissioner Post.
Yes, sir.
Yes, I reviewed it and it has my initials and today's date on it.
Is this the body-worn camera that you just testified about containing the interaction with the vehicle that
Yes.
Athena alerted on?
Yes.
True and fair, accurate copy with no alterations or deletions as far as you know?
Correct.
Back was the last time you watched it?
A little while ago. Just
before testifying?
just before testifying.
State officer states, one, been previously provided to defense counsel in discovery. No, Judge.
States one's admitted.
Commissioner Post. Judge.
Yes, sir.
Seats. Check. 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 Right? Hey. Hey. Seats. Check. Let's find it. Oh, I find it. No? Hey, you're good. You're good. Here. Girl, here. Right. Here. Seats. Seats.
For the record, that was about
Check.
in 11 seconds, 2 minutes and 20 seconds. That's all I wish to publish. Leave it up there, though.
Does the other officer's body cam?
Street, the front dash camera shows a better view.
Okay,
It captures.
I'm gonna want to see that.
Hey, you're good. Hey, you're good. Girl, here.
I'd have to find his body cam. I mean, his
Come on.
dash
Seats.
cam. That's for the record, that was about in 11 seconds to 2 minutes and 20 seconds. For the record, that states published. That's all I wish to publish.
The front dash shows
Leave it up there, though.
the entire thing without moving around and everything.
Does the other officer's
Moving away from
body cam?
Let me.
Street, the front dash camera shows a better
Take a look
view.
at that.
Okay.
And then if we need
It captures.
to-
I'm gonna want to see that. Come back either later this afternoon or continue the hearing to the appropriate time when we can.
No, I don't. I'd have to
With regard
find
to-
his body cam. I mean, his dash cam. I've got his body camera
Okay.
ready and queued up, but I have to find his dash cam.
And does the body cam show it?
I think it
If
does.
he's,
Yeah, I think the problem is, I think the front dash shows the entire thing without moving around and everything. Like body cam, the problem is always it's constantly moving away from the.
but if he's sitting, let's get him back so I can take a look at that. And then if we need to get more, we can come back either later this afternoon
afternoon or continue the hearing to the appropriate time when we can get that. So with regard to
That's it. I have.
this part of it,
That's all I have for this.
okay, Mr. Galmore?
Now, I'm gonna ask as many questions as I can, and I may have to follow up with an additional question or two once we've seen the other videos, if necessary.
Okay.
But if he's sitting,
I'm sorry, what was your name again?
Tiffany Williams.
Williams, Officer Williams.
Yes, sir.
And then if we need to we can.
Where was this dog certified? You said NDAA?
NDDA, we go through, one of their guys in Baytown. He has I can't remember the address is, but the certifier has a building they use in Baytown.
Okay. Do you know where the dog was actually trained though? Like originally?
Through Jefferson County.
Like they took the dog as a puppy and taught it how to be a drug dog?
I got her as a puppy and we did all the training here with a certified trainer.
Okay, who was the certified trainer?
Bill Crane.
Who was that?
He's a Jefferson County deputy.
Where was this dog certified? And do y'all have like a book you use to train these dogs?
He does all his training stuff that he went through to a school with, and I think I went through a basic school with him, if I remember right, and then I trained almost weekly with them as well.
Okay, let me ask you this. Do you have a book on how to train a canine, drug dog canine?
No.
No. So you relied on the training from Mr. Green, right?
Crane, yes.
Bill Crane.
Yeah, Bill Crane.
That's what we're on here on Mr. Green's case. Okay, so Bill Crane trained the dog. You don't know exactly how Bill Crane trained the dog.
I was there with him for everything.
Okay.
So, yes.
Did you ever see Bill Crane refer to a book on how to train the dog?
Not during our trainings, but I know that he has before, just previous knowledge with him.
Okay. Then if you were around in the very beginning when this dog was trained, a dog is trained to hit, right?
They're trained for a response to odor.
Okay. That's what the industry calls a hit, right?
We refer to it as a response to odor. You have a final response to odor, you have just response to odor.
Sure. But every dog, when they're trained to give a final response, right?
Correct.
That's kind of how the reward system is based, right?
Not necessarily.
Well, but to be fair, in order to know that the dog did the job correctly, you have to know that the dog is giving you the response.
Which would be the change of breathing and change of body posture.
Right.
They're trained for a response to odor.
But each dog is trained to give a final response.
We refer to it as a response to odor. Yes, they're all trained to it. Yes.
Okay. Changing breathing pattern is not a final response, right?
Not necessarily. I mean, you have your everything that leads up to it. If you don't have that stuff, then you're not going to get to necessarily the final. In a case like this, we're on a major highway with a lot of vehicles moving around. We don't always wait for that final. Once we have enough for response to odor, which is what she showed in the video, then we'll move on from there.
What's the final response for this dog?
Change of breathing. Or her final response is she normally sits.
Sit.
Yes.
Okay. So this dog is trained to sit when it smells drugs.
That's her final response that she shows.
That's what she's trained to do.
That's what she's trained to do for her final. Yeah.
Okay. And so whenever you are in a not out on the field, but you're doing like your certification, right?
Once we have enough.
Do you have to tell the judge beforehand what their final response is? Passive, aggressive, something like that?
I don't think it's a requirement. I think we normally do, but we're all normally familiar with each other as well.
Are you familiar with the narcotic detection standards by the National Narcotic Detector Dog Association?
Yes.
Okay, because that's the association your dog was certified by.
Correct. I don't remember ever telling them.
And so you never told the judge that my dog's trained to sit?
I can't
But your dog is trained to field, but you're doing like your certification. And whenever you've been in these certifications beforehand, what their final response is? Passive, aggressive, something. So when you're doing the certification testing or retesting, aren't you responsible for notifying the judge the type of alert that they can expect?
I don't remember if we tell them directly or not. Like I said, we're familiar with each other. I don't remember when we go in, we go, hey, mine's passive, I don't remember ever telling him that.
So you've never told the judge that my dog's trained to sit?
I can't recall.
Okay, but your dog is trained to sit.
That's what I've trained her, yes.
Okay. And whenever you've been in these certifications, has your dog sat when it found the drugs? So when you're doing
She has, but there's also times she has not, because all we have to do is inform the judge that our dog's in odor, and they tell us yes or no.
they can expect. So you keep saying this change of breathing pattern and body posture is to you is notice that the dog is hitting on something.
Correct, they're showing a response to the odor that they're smelling.
Where in any of your training does it say that you're allowed to rely on something other than the final response?
Multiple case laws in all our training.
Case laws, is that what you said?
Yeah, I don't ask me which ones. I'm not gonna be able to be specific right offhand.
Is that how you trained your dog, was using case law?
We all have to be familiar with it, so we're aware what can and cannot do.
You think, so Bill Crane, he would actually be the person who could testify as to how the dog was trained, right?
Yes.
Okay. And exactly what the response the dog should give?
Yes, he would be able to answer all of those questions.
Okay. And whether in a particular situation the dog actually hit or did not hit?
Yes, he would be able to explain it. I mean, he's gonna explain it the same way I am, but just change your breathing, change your body posture, but he will have all the technical terms for you.
So what's the standard breathing pattern for your dog when it's not alerted?
So whenever you see a difference, she'll close her mouth and she'll start sniffing really hard. That's what we normally look for. Same thing when they're tracking. You watch them picking their head up, putting their head down, the way they're breathing. So with her, normally she's gonna close her mouth. She's gonna and she's gonna start sniffing a little bit harder, and she's gonna try to get to that source.
So what you're saying is that she thinks she smells something, so she sniffs harder and tries to then go towards where she thinks she's smelling something. That tells you that that's a hit.
There's more to it, but that's part of it. Yes.
But you don't have a book on how this dog was taught. No book at all.
I don't own one. No, I've had them passed on to me from other handlers. We've reviewed stuff, but I don't have one with me.
Have you ever seen in any of the records that you looked at how this dog was? Well, first of all, have you ever looked at any documents at all on how this dog was trained?
I have all the documents. Yes.
Okay, you provided all those documents to him, right? Mm-hmm. Where do you have those documents with you?
No.
Okay. Do you have them electronically?
Yes, at the police department does.
Is there anywhere in there that says how that dog was trained to hit? Okay, so you don't have.
It should be in the beginning. We should go over some.
What was the name of that document?
It's all in there. They're all training records.
You don't know the name of the document that says how the dog was hit?
No, because when I log everything, I normally do a training date and who I'm with.
Well, first of all, whenever we're on a break next, do you think maybe you could see if you could find any document at all that discusses how your dog is supposed to hit whenever it smells drugs?
I'm not gonna have it with me.
Well, but I mean, you can look electronically. Can you look electronically?
That's gonna be the police department.
Okay, so you're really not sure. You think there's a document. You think you gave it to him.
There's all my training records. Now, if it specifically says she sits, or if it just says a final response, I know with the stuff with this stuff that she shows a response to odor. That's gonna be the difference. That's what you're gonna look for.
My question though is there anything in your records that says this dog was trained to sit when it smells drugs?
I would have to go back and look if it's specifically stated in it's sitting or if it's a final response.
What's to stop you from saying, hey, I taught this dog and, I could just tell you, he just acted different, so that's a hit.
Well, everything on everything we go by, everything we watch is on video. So I can't just say, oh, well, they did this and I have to have the proof there to back it.
Can we pull that up real quick? I can do it.
You don't look for.
My question though is there anything in your records that says this dog was trained to sit when it smells drugs?
I would have to go back and look if it's specifically stated in it's sitting or if it's a final response.
What's to stop you from saying, hey, I taught this dog and, I could just tell you, he just acted different, so that's a hit.
Well, everything on everything we go by and everything we watch is on video. So I can't just say, oh, well, they did this and I have to have the proof there to back it.
Can we pull that up real quick? I can do it.
You just don't click.
Yeah. Hey, I'm gonna walk right here to move them up.
Go ahead, whoever wants to go.
A couple of things just to clarify and a couple of follow-up questions. I think you heard me saying a minute ago something you might have said, but I want to make sure that we're on the same page with it. Back on page 9 of your report, you have that, Andy?
Yes, sir.
We have not seen it on the video. I'm assuming the video will corroborate this, but you said in your report that Green.
With regard to the suppression, go ahead, whoever wants to go.
A couple things just to clarify and then a couple of follow-up questions. Reasonable suspicion that narcotics were in his vehicle.
That's correct.
Those were your words, right?
Yes, sir.
Does no one put those words in your?
I think you heard me saying a minute ago something you might have said, but I want to make sure that we're on the same page with it. Back on page 9 of your report, you have that, Andy?
That is what starts the process to get K9 to be en route.
We have not seen it on the video.
Now,
I'm assuming the video will corroborate this, but you said in your report that Green asked you why you wanted to search his vehicle, right?
That's correct.
And then you told him it's because you had reasonable suspicion that narcotics were in his vehicle.
That's correct.
Those were your words, right?
Yes, sir.
Does no one put those words in your mouth?
No, sir.
You chose the word reasonable suspicion.
And the reason why I chose those words was because I had reasonable suspicion to notify him that there's narcotics in that vehicle. And that is what starts the process to get K9 to be en route.
Okay, perfect. Now,
you said in your report, even though a window.
you then, I believe we did say this on the record, but just to be clear, you then also put in your report on page 9 that after Officer Williams advised you that her canine alerted, that provided you with probable cause to search the vehicle.
That's correct.
Earlier about the
And the reason why I chose
prosecutor.
those words, and once in the vehicle, then I smelled the odor of marijuana, additional probable cause.
And that's important because had you smelled the marijuana before you entered the vehicle, then that might have provided probable cause to search without the canine,
That's correct.
right? And even though a window was down, you never smelled the marijuana.
And I smelled it from outside the vehicle. That's right.
Also, put in
And
your report
so
on page
you,
9.
at this point, he's
that
someone
after
who's about to
Officer
go to
Williams
jail,
advised
right?
you that her canine alerted.
And so
Now-
when you got him out of the car, did you
You testified earlier about the prosecutor,
And once
did you
in the
tell him that he
vehicle,
was
then I
under
smelled
arrest?
the odor of marijuana.
I'm sorry, about,
And that was-
that you were going to arrest Mr. Green no matter what.
You told
For the misdemeanor, yes.
that might
It's your testimony that when you were getting out of the vehicle, that you were going to arrest him at some point, no matter what.
That's correct. I want to keep that from him until.
And so you, at this point, he's someone who's about to go to jail, right?
That's correct.
Okay.
Yes.
And so when you got him out of the car, did you tell him that he was going to be arrested?
No, not
Did you tell him that he was under arrest?
I just told him he was detained and to have a seat on the ground so we can further conduct our investigation.
So you told him he was being detained.
I don't know if that's my exact words, but if we watch the video, that's fine. We can-
You certainly didn't tell him he was under arrest, though.
No, I want to keep that from him until
And so
the last second.
but he's basically
Because you were trying to get probable cause to search the vehicle.
That's correct.
you got him out of the car.
And so-
Additional evidence.
Did you handcuff him?
Not immediately, no, sir.
Did you tell him that
Okay.
he was arrested?
Did you put him in your cruiser and lock him in there?
Not immediately, no, sir. Had him come out and sit down on the sidewalk.
You told him he was being detained.
Okay, so he's basically about to be arrested, but for a long time, you don't handcuff him, you don't put him in your car, you let him walk all around the area, right?
That's correct.
But he's basically, he's secretly being arrested though.
So I knew if I placed my handcuffs, then I would have to read his Miranda warning right there on the street to further ask him questions about the license plate and the money in the vehicle.
So you didn't arrest him because you wanted to trick him into talking.
I just wanted to get more information about him, violating his rights. If I would have put him in handcuffs, then he would, I would have to read his Miranda warning and then he can shut down right then and there.
So your concern was is if you told him he's being arrested and then he was aware of his rights, that he might exercise his rights.
That you were
That's
gonna
a fair way to say yes.
get him to talk to you.
So I knew if I placed my handcuffs,
Now-
I had to read his Miranda warning right there on the street.
When you called the DA's office at the scene, was it their idea to trick him by not arresting him?
To the characterization about being tricked.
Well, that's what he just kind of said. Was it their idea?
No.
Okay, so it was your idea.
No, it wasn't, there was no tricking whatsoever. I knew what I could do, what I couldn't do without violating his rights.
When did you formulate the idea that you were going to not arrest him in order to get him to talk to you more?
Not arrest him, probably
Yeah, I mean, when you got him out of the car, you didn't arrest him.
Oh, when I asked him to get out of the car, I already knew at that point that he was going to go to jail.
Okay, so you had made it up in your mind at the time you're getting him out that he was going to be arrested, but you were not going to arrest him right then.
That's correct.
And that was for the purpose of so that you could talk to him and get more information.
Further investigate both offenses.
So it wasn't the DA's office that told you to go that route.
That's correct.
So did they tell you to change your route at all?
No, they just gave me advice on how to properly go about investigating the money seizure portion of it to get additional evidence so the dog can alert to owners in that vehicle, which later on, if you continue reading the report, the dog alerted again back at the station during the 5-bag test. It went straight to that, his money in a bag. And the additional evidence of reading him Miranda warning at the jail, him not admitting or not being very forthcoming with us in the interview at the jail.
So did they tell you to change your?
And he couldn't explain where he got the money from. He hadn't had a job since 2023.
Okay. We'll get to that in a minute. Sorry. As far as the topic of you had already decided to arrest him, okay? It's that discussion that we've been having today. And so that because of that, you were going to find what was in the car anyways, right?
Inevitably, yes.
That's kind of what you said a minute ago, right?
That's correct.
Okay. When was the last time that you discussed that topic? Just that topic with the prosecutor.
The first time or the last time?
The last time.
Before we came here, we sat down and know the questions he was going to ask me.
Okay. When was the first time that discussion occurred that you were going to arrest him anyway, so you were going to find it anyway?
It was last week, I think it was.
Okay, so the first time that ever came up in this whole investigation for you was last week.
Your Honor, that's a complete mischaracterization. The first conversation we had was last week, but that wasn't necessarily the first time, quote unquote, it came up.
I'm asking the questions. I'm not giving.
I just want to make sure the court's not misleading.
So you're objecting to his answer.
I'm objecting to the misleading nature of the question.
My question is, and I'll clarify, when was the first time you had the discussion with the prosecutor that you were going to arrest him anyways, so you were going to find the contraband anyways?
No, today we discussed this, and then I told him that he was going to jail regardless. That came from me. Basically, he was going to go to jail regardless for this offense, the misdemeanor offense here. The money laundering didn't come until after I started investigating the further possibility of seizing the money and going the route for filing the case for money laundering.
I understand that. Okay. You said that came from you today, that you were going to arrest him anyways.
Yes.
So that's today, but today's not the first time you discussed that topic with the prosecutor.
So last week we talked that this case is going to trial that either me or me.
Right.
And then we talked about it today.
Okay, so did that topic come up last week as well?
No, that's my recollection.
It came up today in discussions with the state for the first time.
We talked, we moved to the report, cut it up to the report.
Okay. And were y'all discussing that in context with whether it was a good search or not? I understand that.
It was more conversation about some new case law that came out.
What case law is that?
I think it was, what was sent to me was a State versus Oregon or something like that in October of last year, but that was after this incident had occurred.
What does State Oregon versus Oregon say? I don't know. Did that topic come up last week?
Can I look it up and read it to you, Jordan?
Yeah. You have it like in paper form with you or something?
No, it was on my cell phone.
Okay, go ahead. I'll be just saying.
You got that case law? I think it was case in October 31st of 2025.
Context with whether it was a good search or not.
About the
Oregon.
Oregon. Yeah.
Is that the dog can't stick their nose through the
continuously through the window? Yes.
Dog can't stick their head through the car. That's a search. You became aware of that yesterday.
It violates the Fourth Amendment right. So basically, if the dog continuously sticks through there.
Okay. So if a dog sticks their head through an open window, that can be considered a bad search.
Continuously.
And you got that case law when? It does go to his testimony today, though, as to I was going to find it anyway.
About probably the day before here.
The day before today?
Yeah, I was talking to K-9 sergeants with Beaumont and the K-9 officer that was here.
So
the proceedings demonstrate the court's emphasis on balancing accountability with procedural fairness
Okay,
across
so
a
if a dog
variety
sticks
of
their head
criminal
through an open
matters.
window, that can be
The judge
considered a bad
consistently
search.
ensured that each
Continuously.
defendant understood the consequences
And
of guilty pleas,
You got that
waived
case
rights
law in.
knowingly, and was mentally competent before accepting any agreement. In Mr.
Probably the day before here.
Valentino's case,
The day before
the
today?
court
Yeah,
honored a
I was talking
negotiated
to,
plea while limiting the requested
K9
delay
sergeants
due
with
to
Beaumont
concerns
and
arising from his criminal
the
history,
K9 officer that was here.
making clear that compliance
So-
with court orders was essential to preserving the agreement. Other hearings reflected similar judicial discretion, including granting continuances to allow additional evidence to be reviewed, approving deferred probation where rehabilitation appeared appropriate, and ordering a pre-sentence investigation when more information was needed before sentencing. The expunction hearing also highlighted that statutory eligibility requirements control the outcome regardless of how much time has passed. Overall, the proceedings illustrate that negotiated resolutions depend on honesty, preparation, and adherence to legal conditions, while judges remain responsible for protecting both the integrity of the justice system and the rights of everyone involved.